Dave Aronberg is a state attorney in Florida, and we have turned to him for his legal analysis and insight as authorities search for Laundrie. And tonight we're asking him some questions that you sent us about this case, and you have a lot of them. Dave, appreciate your time as always. Thank you.
Thanks for having me back, Marty.
So we're going to string through a few of these questions from viewers. They sent us these video questions on Twitter, and I want to begin with a question that Sherry had for you.
If the Laundrie family attorney knows exactly where Brian is that covered under attorney-client privilege?
Well, Sherry, when it comes to affirmatively telling law enforcement where someone is, no one is required to do so. Now, don't even think of it as terms of, is it Brian's lawyer or not? No one is required to go affirmatively to a police officer and say, hey, I know where he is. Now, if you're asked by law enforcement and you lie, that's a crime. And lawyers, although they do have attorney-client privilege, there's still something called a crime fraud exception. So if the lawyer is helping Brian escape, if the lawyer is destroying evidence, then that would be a crime and the lawyer could be charged with a crime. But no, the lawyer, even if he knows where Brian is under no obligation to affirmatively go to law enforcement and tell them.
That's a question I know a lot of people have had, Dave. All right, this next question comes from Dalton about cold cases. Listen.
I was just curious, how much time has to go by without any new leads, any new information, any new tips for this to transition into a cold case?
A case becomes cold, Dalton, when all investigative leads available to the primary investigators are exhausted. And so then it goes into like a cold designation, and it's usually after a period of time. So in many jurisdictions, it's about 3 years. So this case is long before it gets to a cold case. It's nowhere near a cold case yet, so you don't have to worry about that. But even if it is a cold case, they are periodically reviewed. There are new technologies like DNA that help break those cases. So it doesn't mean that the case is just put aside forever. It still remains open in its own way.
Dave, new tonight, we had heard that the Teton County coroner is going to come out tomorrow and hold some sort of press conference. We anticipate it is in relation to Gabby's autopsy. So this question is connected to that and comes from Andy.
If the autopsy is done and the coroner's report is complete, is it unusual that they haven't released Gabby's remains to her family yet? And what might that tell us about the investigation?
Well, I don't think we know if the remains have been released to the family. I haven't seen that yet. But in general, once the tests and all the physical evidence is taken, then they release it to the family within 48 hours. At least that's what happens in Florida. Even when the cause of death is pending, even when the toxicology reports are outstanding, the body is generally released to the family within 48 hours after the physical evidence is removed and the tests are taken. So I don't know whether the body here was sent to Gabby's family already, but I wouldn't read too much into that. Sometimes also in high profile cases, you can see that law enforcement will be extra careful. Medical examiners will do more tests because of the great public attention.
And timing and strategy all play into this. All right, Dave, this next question is from Shinu.
My question is as follows. If Brian Laundrie is caught and it's determined that he was somehow involved in the murder, then which authority is legally entitled to try him first?
He could be tried in Wyoming, where the murder takes place. That's where he would be tried. But the question is whether it would be the state prosecutors or federal prosecutors. If he committed the murder, allegedly, if he committed it at the national park, Grand Teton National Park, that's a federal property, and the federal prosecutors can prosecute the case. Generally, when there is a battle between the feds and state prosecutors, the feds generally win. State prosecutors usually defer to our federal counterparts.
All right, Dave, I've got a couple of questions here from folks on Twitter that they sent in. This is from Charity. She said, I want to know when the parents hired an attorney and why did they hire him if they did nothing?
Well, as a prosecutor, we always ask the same thing, but everyone's entitled to a defense. Everyone's entitled to remaining silent. And so you don't necessarily look at someone's decision to hire a lawyer as evidence of guilt. They may just want to protect their rights. You could look at it from their perspective that they want to make sure they don't say or do something that would put them in legal jeopardy if they shouldn't be in legal jeopardy. Now, I know to the public, it's like, hey, why do you need a lawyer unless you're guilty? But there are a lot of reasons why someone would not want to come forth with information that could make them look guilty when they're not. So I'm trying to look at the best way for the defense here, but generally I'm with you. As a prosecutor, we often question why this person lawyers up. It usually is a sign of guilt. And by the way, you can't refer to that in court. Like you can't say, hey, they lawyered up and they remain silent, and that means they're guilty. They have the right to remain silent. They have the right to lawyer up, and it can't be used against them in a court of law.
Whether you like it or not. Dave Aronberg, great questions from everybody at home on Twitter tonight. And Dave, as always, thank you for the great answers. Appreciate it.